Welcome and thank you for standing by. At this time, all lines are open and interactive for the duration of today's conference. To avoid background noise, please press star followed by the number 6 to mute or unmute your line. I would like to turn the call over to Mr. Aaron Shapiro. Sir, you may begin.
Thanks very much. My name is Aaron Shapiro. I'm the Director of Policy Research here at Morningstar. And welcome to Morningstar's Fiduciary Rule webinar, a plan sponsor perspective. I'm so pleased to have George Tsipsakos and David Levine from Groom here. I just want to start with a few general housekeeping items. First, the session is being recorded. We'll share the recording after the presentation. We'll be saving questions for the end, and if you type them into the Q&A box, we'll crew them as we go, and we'll get to them during the presentation if they line up, but we'll definitely try to get to them at the end as well. And just a disclaimer here, this is, of course, not legal advice. Just as a quick introduction, the fiduciary rule is a huge change in the regulatory environment, and basically, Morningstar's posture on this is that DOL is trying to align regulations to reality. The regulations they changed really haven't been updated in most cases since 1975, and that means that they existed before the 401k existed. So the world has changed quite a bit since these regulations were first promulgated, and this update accounts for that major shift in the way that people are saving for retirement. And with that, I'll turn it over to David.
Good afternoon. Thank you all for joining us. It's really great of you to be here with us today. What we're going to try and do is first start off a little bit with a bit of what we're going to cover today. So we're going to talk about that. George and I are going to go back and forth a little bit as we go through today. And in this process, hopefully we answer some of your questions. There is, as you know, a chat box. Feel free to ask questions. We'll try to weave in if we can as we go forward today. At the same time, we're just going to move our way through, and at the end, hopefully we'll have a little bit of time for questions. So what are we going to do today? Well, first we're going to start off with some brief takeaways. The key here is we realize that your time is valuable. We thought we'd try to sort of summarize in very brief form, what are we hoping that you get out of this presentation today? What can you sort of go with and say, well, what does this mean to us? But then we're going to sort of get into the process. George is going to do a brief review of the final regulation. For those of you who have been through this a million times, we promise you it will not be a word-for-word recitation of all 1,000 pages. Instead, it will be more of a review really with a plan sponsor focus. We know that we have plan sponsors and some service providers on the line today, but it's really going to be a plan sponsor's focus as to what does this mean to you? Because you read so much in the press, so much in the news. We're going to try and boil it down, in a sense, to basics to see how we go. Then we're going to talk about the impact of the fiduciary regulation on the plan life cycle. What does that mean? We're talking about different activities that the plan sponsors and employer plan fiduciaries go through to actually run their plans, and how does this regulation potentially impact you? We have 3 slides on that, and the goal is to really spend maybe 15, 20 minutes talking about those things. And as we said, we encourage your questions through the chat box. Then we're going to wrap up with some plan sponsor action steps, short, medium, and long term. These action steps kind of dovetail back into our takeaways, and we can do Q&A after we're done. But rather than spend more time talking about what we're going to cover, why don't we just dive right in and get into what we're going to talk about. So for today, let's talk about our takeaways. A lot is in flux right now. Why do we start off with that? Because anybody who tells you that A, you need to do something and have all your answers today, or B, that every answer is clear, is either omniscient or I think they're trying to be calming, but it doesn't mean you actually need to go that far right now. But right now, we have a regulation that was published, and it came out 6 months ago. But the real issue is that regulation, there's a lot of questions. And you all as plan sponsors have all your service providers, and they are struggling mightily on how to get through these requirements. It's not that they've done anything wrong necessarily, but they're trying to figure things out. So we're going to try and frame today as, well, what could you consider doing in each of these steps and evaluate what do we do? But don't assume everybody's going to have a silver bullet for everything and everybody's going to have an answer. It just doesn't work that way right now. and it's probably going to consume more of your time and effort than you need, and it's going to be a very frustrating experience right now. We're going to talk about time frames. For now, you should ask questions and prepare, but don't expect the immediate answers. That's the key point. So talking about short, medium, and long, these are high-level takeaways. We're going to get more into them as we dig deeper. In the short term, ask. Say to your service providers, and this includes everybody from your consultants to your outside educational service providers to your record keepers to anybody you use on managed accounts. Just ask them, what are you doing for the regulation? When will we be hearing from you? Don't expect them to say, oh, I'm ready today. And go back and pull your existing agreements. It was probably several years ago that with all the fee disclosure rules, you were going through a lot of your agreements and trying to figure out what was being disclosed. Did it line up with the disclosures for what the providers were telling you? Now is a good time to pull out those old materials and just get a feel again for what they say in writing they will do. We all know that there's marketing and there's reality, and there's a lot of both in this discussion. But the idea is to start with the original agreements and have them and read them over and say, well, what do we think we need to do? And if you don't have the internal expertise, you have advisors, you have consultants, or even ask the service providers, what are you thinking of? Obviously, even when you're dealing with your lawyers, everybody is has a little bit of built-in skepticism. So it's good to have someone independent in helping you with this, but that's a key starting point. Medium term, the key thing to keep in mind is for everybody is to say, well, what are you doing? And to actually start getting that information and parse through it. You're going to get glossies and you're going to get contracts. Glossies are going to be the marketing materials. Contracts are going to be the real meat and potatoes. You should be ready to read both and say, how does it line up with what we've got? And at that point, you can review those new agreements and say, is it consistent? We all know that agreements get revised, and sometimes they're revised for the fiduciary regulation, but there could be other improvements, and some could be improvements, but some things could be changes in what you're used to. So go through them and look at them carefully. It's not that anybody's trying to play a game of switcheroo on you here, but the idea is to understand what has changed in your agreement. That's your medium term, because by April of next year, people are going to want new agreements signed. Longer term, you should look to see if people are actually doing what they're saying. Are they giving you the disclosures they promised to give you? Make sure you check those boxes. And also see what the Department of Labor and Enforcement is doing. Obviously, hopefully it doesn't involve your plan or you, but there's going to be articles. People like George and I are talking heads. We talk a lot. There's a lot. Our firm puts a lot out. Morningstar puts a lot of things out. And the idea is to look at those materials and keep abreast, because this is going to be an ever-changing landscape. Come early next year, by April, everybody's going to pop their head above ground and say, this is what we're doing. But the catch is going to be, it's going to be all over the map. And then everybody will start copying each other, and it's going to be this giant circle for a good period of time. So with that said, those are the basic takeaways of where we're going to be. I'm going to hand it over to George to talk about a brief review of the final regulation for the next good bit.
Thanks, David. As you had mentioned earlier, the point of this is to give a brief overview. We're not going to hopefully dull you with all the intricacies of the exceptions and everything within there, but we should hopefully you'll be able to take away the broad generalization of what it means to be an ERISA investment advice fiduciary under this rule. So why the DOL act here? Well, as Aaron stated, with the proliferation of 401k plans, IRAs, they've viewed their the current model is outdated and no longer suitable for the current market conditions. So they've decided to expand the definition of fiduciary advice. And what's that mean? It means we're going to have more fiduciaries for services that people hadn't previously considered fiduciary advice in the past. So, with that, as David mentioned earlier, you're going to have to go through your prior agreements and your different relationships with your vendors to see how this touches, how this rule touches them and how things may change on a going forward basis. So why don't we get into, who might be a fiduciary now under this new rule. So the basics. To be a fiduciary under this new rule, your service providers will really have to fill in 3 buckets. First, they're going to have to provide an investment recommendation, and we'll talk about that in a second. Secondly, they're going to have to get paid. They're going to need to receive a fee, either directly or indirectly. And, we can tell you that the Department of Labor views this prong in particularly in an exceptionally broad fashion. So if they're receiving some compensation from the plan, the Department of Labor will deem or consider that condition satisfied. And third, you need to satisfy, or the service provider is going to need to satisfy the various relationship conditions. So with that, we'll get into first, what's a recommendation under this rule? And under this new framework, the Department of Labor built off of some previous FINRA guidance, some priorly held FINRA guidance, and defined, what a recommendation is as a communication that's based on its content, context, and presentation would reasonably be viewed as a suggestion that someone engage in or refrain from engaging in a particular course of action. Now, the Department of Labor did say that there's a few key considerations to determine whether a recommendation has been made. First, was that communication individualized to the advice recipient? Was the communication a general, explanation of market conditions, or was it a communication that says this product or strategy may be right for you? That's something that folks need to consider. Secondly, and we'll get into what type of investment recommendations the department was covering, but they provided a few examples. So, for instance, providing a list of securities would be considered a recommendation, even if the individual wasn't recommending one particular security. Also, the Department of Labor introduced what we call the so-called aggregation principle, which is somewhat new to the area, or is very new to the area, but causes some concern amongst us lawyers in the sense that even if no particular communication rises to the level of being a recommendation under the rule, multiple communications in the aggregate may be considered a so-called call to action or recommendation. So what are the types of investment recommendations that someone needs to make in order to become a fiduciary? Well, first, recommendations of individual securities, buying, selling, or exchanging investments, or from a plan or IRA, or distributing those securities or investments from the plan or IRA. Those will be recommendations. Communications dealing with that set of facts will be a recommendation. Secondly, recommendations of investment management. So what's investment management mean? So recommendations of investment strategies, recommendations of portfolio composition, recommendations of other people, and this one's important, recommendations of other people and third parties to provide investment advice or investment management services would be considered fiduciary advice, and recommendations to roll over or take a distribution from the plan would be considered fiduciary advice. Whether to do it, in what form to do it, and where to place the money, all would be considered fiduciary investment recommendations under this rule. So we talked quickly about what what a fee means. It's exceptionally broad. The service provider needs to receive a fee directly or indirectly. As a service provider, if you're concerned that the individual or entity is providing investment advice under this rule, and they are getting paid somehow or in some fashion from your plan in connection with your plan, whether it's directly or indirectly through commissions, sales charges, or other various types of compensation that they could be receiving from third parties, or frankly, potentially for providing other services, could be considered compensation for purposes of this rule. And then lastly, the fiduciary needs to provide the advice, the service provider needs to provide the advice and satisfy the various relationship conditions. So they either need to tell the plan fiduciaries that they are a fiduciary. So if the service provider says they're a fiduciary, they're going to be one. If they provide the advice pursuant to a written or verbal agreement, arrangement, or understanding that the advice is based off of the particular needs of the person who receives it, they're going to be a fiduciary. Or, lastly, if the advice is directed to a specific advice recipient and is based off of their particular investment or investment management decisions, they're going to be a fiduciary as well. So, that's kind of the framework that you need to look at in terms of deciding whether someone's providing fiduciary advice under this rule. So what are the next steps? If someone's a fiduciary, you first need to figure out whether they're a fiduciary and go through that type of analytics framework to determine whether they satisfy the test. If so, is there a prohibited transaction involved? And we'll talk about what that means in a second. And if there is a potential prohibited transaction involved, is there a prohibited transaction exemptive strategy that the plan service provider is using in order to continue providing services? And with that, we'll move on to the next slide. There are a handful of exceptions, and these are important exceptions to figuring out whether the plan service provider is acting as a fiduciary or not. And we'll come back to the employees exception, but these others, really apply to plan service providers. So there's the platform provider exception. So those entities that make available a investment platform or similar mechanism for the selection of 401k plan fiduciaries to offer their participants, so long as those platforms are not individualized to the plan itself, they may be used here, and those service providers may avoid fiduciary status. We caution folks every day that this is a relatively narrow exception, and you need to be careful if you're trying to rely on it. Hire me exception. This is one that when the rule came out, and you could still go out and look, throughout the internet, there's going to be articles of people saying that DOL fixed everything. Look, they provided hire me. Service providers can offer their services and they can avoid acting as fiduciaries when selling their products and services to the market. Not so fast. The department was pretty clever in all of their initial marketing materials in describing the rule, in that they had stated that they had fixed this problem, but they really hadn't. So hire me, what's this about? An advisor or other service provider can recommend that the plan hire themselves to provide investment advisory services to the plan without being deemed a fiduciary. However, if that recommendation is coupled with a recommendation of what they would do if hired, you can or the service provider can no longer use the hire me exception. And frankly, in almost every situation, you can imagine where someone comes in to the plan offering to advise them on a particular long-short strategy, for instance, and the plan fiduciary say, that's great, can you give us a little bit more detail about how you would operationalize this strategy? And as soon as they go ahead and describe how that might work, well, you've just crossed over this hire me exception and are providing fiduciary advice. The independent fiduciary exception. This is another important one for plan service providers, particularly those who are offering services up the chain, so to speak. So what is the independent fiduciary exception? This is the exception that the department made available to sophisticated plan fiduciaries, meaning that the department carved the rule into kind of two different buckets, right? So they view the retirement services market as those who can understand when they're being sold to, the sophisticated fiduciaries, and those who can't. And the department had essentially demarcated a line at $50 million to figure out whether you could, understand that you were being sold to or not. So for a certain group of individuals who are RIAs, broker-dealers, banks, insurance companies, or independent fiduciaries with greater than $50 million in assets under their control or management will be deemed independent fiduciaries, meaning, for purposes of this exception, meaning that service providers can sell their services to those independent fiduciaries and avoid fiduciary status for that sales activity, provided that the conditions of the exception are met. And those conditions include, that the service provider reasonably believes that for instance, if the independent fiduciary is a plan fiduciary with greater than $50 million, that they reasonably believe that the plan fiduciaries control or manage greater than $50 million, that the service provider reasonably believes that the plan fiduciaries on the other side of the transaction can, review and understand the terms and conditions of the agreement, and the service provider cannot be paid directly for providing that recommendation to the plan fiduciary. So, same long-short strategy hypothetical we were talking about a second ago. Imagine that the manager is providing a sales pitch to independent plan fiduciaries. The plan has, let's just say, $1 billion in assets, so they satisfy that condition. The only fee that the sellers of that vehicle would receive is for the investment management of the product. Well, they could satisfy the independent fiduciary exception because they're not receiving a fee directly for providing the recommendation to use that vehicle. Moving on, there's a selection and monitoring assistance exception, which is available to those, and particularly this is helpful to record keepers. So if a plan fiduciary is asking, a record keeper, our large cap, growth fund is underperforming. We'd like you to provide us with a list of securities that might work, provided that the conditions of the exception are met. They can do that. One of the exceptions, or one of the conditions, is that the plan fiduciaries have to actually describe the criteria that they're looking for. So we're not sure here how many plan fiduciaries will be able to come up with a meaningful list of criteria that they need to utilize this exception. But that's available and it's out there. The general communications exception is also available. This is for service providers who may provide general market commentary, general circulation newsletters, folks like Jim Cramer who are out there. And the idea behind this exception is that, well, Jim Cramer is not providing specifically directed investment advice to any individual. He's sort of out there giving, his thoughts on the market to anyone who's willing to listen. Remarks at widely attended gatherings can fall within this general communications exception. Providing price quotes or prospectuses also fall within this general communication exception. And then investment education. Investment education is important in the sense that they largely maintain previously used IB 96-1, which provided for 4 different types of investment education that could be provided to plan participants. And the department had broadened this to some degree, including that, investment education could be provided to plan fiduciaries, IRA holders and owners, the IRA plan participants themselves. But for the most part, they kept the general conditions, although there was one exception, which we'll talk about in a second. So what are those investment education different prongs of the exception that are available? Providing general financial and investment information. That's available to service providers. So, describing, interest rate risk, generally dollar cost averaging, that sort of thing isn't considered fiduciary advice for purposes of the rule. Providing general plan information is also not considered fiduciary advice and falls within the education exception. So therefore, the benefits of plan contributions, the liquidity rights of a plan versus an IRA, all of those would generally fall within the general plan information exception. Interactive investment materials, the provision of interactive investment materials are not considered fiduciary advice. Those investment materials need to take into account the outside the plan assets of the individual, so they need to consider Social Security, equity in a home, etc., when providing these interactive investment materials to the underlying participants. And asset allocation models, and this is one place where things have changed. So the provision of an asset allocation model won't be considered fiduciary advice, provided that the conditions are met. And the conditions are relatively straightforward and mirror those from before, except that the asset allocation model cannot provide a description of the underlying investment alternatives to the plan participant within the plan, within an IRA. They can within a plan, provided that those are designated investment alternatives under the plan. And with that, we will move forward and we will skip BIC and BIC Light because it's not all that relevant for plan fiduciaries at this time, and we'll move forward to a brief review. David?
Sure. As we move forward, so let's tie this back to plan sponsors. A lot of plan sponsors at this point, when they're hearing about all this, they read what's in the newspaper, they read what's on TV. And if you're a plan sponsor out there, the big question is what's really going on. There's a lot of marketing out there where people say, I've already been a fiduciary or I'm now going to become one. That is sort of the baseline discussion here, because a lot of people are currently saying, adapting, and also they're trying to put themselves in a strong position to deal with the regulation. They view it as a business opportunity, and they view it as a chance to, in a sense, take business from someone else. And part of what we're seeing on this marketing terms versus realities, you've probably been barraged for the last year or two with questions from different people saying, oh, well, I've got this service, I've got that service. You might hear 316, 321, 338. These are all these concepts, and that's going to get layered on with this regulation. Take a step to breathe is the key thing here. People are going to tell you, well, this is no longer allowed, or that is no longer allowed. The answer is, there's so much gray here. Don't take what people say is a marketing term to match the legal reality, because it doesn't always line up. And it may look fancy and formal, but you need to step back as a plan sponsor and really evaluate. But there are some hard conversations to come at this point. The hard conversations that you're facing at this point are that some service providers, you're going to find out that in a completely legal way, they may have been getting paid, they may have been taking on certain roles or activities that they're either going to have to change how they get paid, or they're going to change what they are willing to do for you, and they might try to charge you more. And you have to look and say, why are you doing these things? And in some cases, it may be perfectly legitimate. But as the plan fiduciaries, as a sponsor-side fiduciary, your obligation here is to look at these things and say, is this a good use of plan assets and the money in the plan? And the key takeaway right now is to say, what are you saying? And remember, marketing versus reality. They're going to give you a glossy, but look at the contract. It doesn't mean that the glossy is misleading, but the devil is in the details on this rule. George's explanation just now really highlights that point. The actual details and how these rules work, you could spend days on. We had a whole day at our firm on this, where we just talked through things, and it can go on and on. Recognizing you probably don't have the time for that. The key is to start asking critical questions, and don't assume people are out to get you, and don't assume that your existing service providers are out to get you, but also to understand what is changing and how are they changing things for you, and look at the substance, not the flash, including those who come to you and say, this is compliant, this is not. That's your decision. And remembering that we're still waiting for clarity at this point is the key to keep in mind. There's also a bit of confusion we wanted to hit very briefly. You may hear some service providers say, I'm already compliant. The answer is there are some, but very few are. There's always going to be some hiccup that probably comes into play, which means that maybe they need to change an agreement. Maybe they just need to say they're not providing a service. Maybe they just need to clarify what they're doing going forward in terms of what their activities are. But if someone says to you, I'm fine, I'd pause. Not because they might not be fine, but you have to understand why they're fine. And the key is the granularity of this. If someone says to you, well, I'm just your advisor, the question is, what do they do as your advisor? Look at each activity and understand how they do this. Do they upsell you on new services? Take each activity, including the active selling, and say, how does that fit in the rule? And push back and ask. We know that if you're a small plan, you're not going to be able to do the same level of diligence as a mega plan. So we're not trying to say one size fits all here. But the key to keep in mind is to be critical, because the DOL, when they come along, they're going to be looking, and yes, they're probably going to focus more on the service providers, but this helps cover you in the event of the DOL or a plaintiff's lawyer comes down the road. The similar rule applies to, it doesn't apply to me. There's a lot of people out there who are very familiar with securities law compliance over the years. Securities law compliance is different than compliance with this rule. Securities law focuses very much about disclosure shall set you free. Disclosure is only a step in fiduciary compliance under this rule. And that's the key to keep in mind. And we acknowledge as we sit here and talk to you today, there are different views among different lawyers about certain rules. George talked about hire me before. We think we're right. The hire me is narrow, but there are still some people out there going very broad on hire me. And the key is, you can disagree. We're pretty confident we could be going to why for a whole 20 minutes that you don't have with us today. But at the same time, it's important to be critical, but also be critical, and I know lawyers shouldn't say this about themselves, of the lawyers themselves. So that is a key thing to focus on as we go forward. But let's jump on and talk about some of the actual sort of plan life cycle items. And we're going to try and move through these relatively quickly. Well, I was just talking about the example of hiring an advisor. This is a great example of looking critically as you evaluate what to do. Because when you have the initial sales step, and I know it sounds cliche, you're supposed to be looking out for participants and beneficiaries, and nobody's arguing with that. But this is a business. It takes a lot of skill and a lot of people to run these plans. Despite what some plaintiffs' lawyers might like to say, it takes effort to run a plan, and it is not a commoditized widget in every case. The reason I say that is advisors may come to you, and I'm not trying to be an apologist here, I'm just trying to be a realist, is that the advisors may come to you, and in their initial sales process, they're going to say, hire me. Now, except that what George said is that hire me is narrow in scope. And they will come to you and say, you should hire me. And they'll say, I'm going to recommend you changing your lineup, or change your record keeper, or change these education services, because I think this is a good choice. And the thing is, if they make that recommendation, even before they're hired, if you hire them, they're going to get a fee for this. So they'll probably be a fiduciary, and there are some people who said they weren't fiduciaries in the past, but there's a lot of people who said they will, and we're not going to get into the pros and cons of both today. There's different approaches to business. But a lot of people will be fiduciaries, as George was talking about, in the end. So what does that mean? So that means that you have to start looking at sort of the two-step that George was talking about. You need to look first, okay, so they're fiduciaries. Do they have a conflict? This is where they're asking, how are you paid? What relationships do you have with all the vendors? It doesn't mean people can't get paid. It doesn't mean you can't have relationships. But this is about disclosure and avoiding conflicts. And that's kind of what we're focusing on. So you have to look and see, what are they recommending to you, and become a fiduciary. So that could be where the new fiduciary rule comes in. And you'll see people giving you new contracts, new disclosures, even if you're an existing client. Similarly, if someone comes along and says, hey, and I'm going to use a marketing term, it's a legal term, but a marketing term at the same time. I've been your 321, I've been your co-fiduciary, but I'm going to be your 338 fiduciary. Technically, it's a 338 investment manager. In English, they're going to take full responsibility for your investments, and there are 80 flavors of that. Full responsibility can be as small as the head of a pin, or as big as the entire field outside your house. What it means to be a 338 fiduciary is all over the map. Another discussion for another day. The key is, when they're selling you, they're recommending themselves often, not always, for an additional fee. They're going to say, hey, if you hire me for this, you're going to pay me more money. And they might have to be using what's called the BIC Light, which is what George referenced and moved on. The reason why we didn't go into deep on that is that's the provider doing that and how they do it for you. When they come to you, you should say, are you using BIC Light? Are you using BIC? What's your exemption strategy? And then ask them to explain how it works and evaluate it for yourself. So what's going to change? Well, we talked a little bit about this already. First is going to be what is said in initial sales, cross-selling and upselling. And one thing to keep in mind is it's not automatically a fiduciary act to make a recommendation. If you could give a generalized platform or a generalized description of services saying, hi, Jane's Donut Shop or Jane's Tool Company, do you have $20 million in your 401k? For plans like yours, this is an example of something that might be recommended, of a lineup that might be recommended, but it's not individualized to you, and you use it across all of them. That might keep you from being the advisor from being a fiduciary. So there are ways to do this, and if you have over $50 million in your plan, they might try to say you're an independent fiduciary, and they can sell to you. And there's rules there, and they have to give disclosures, and they want you to acknowledge you're independent. And it's important for you to say, is this what I agree to, is what I not? And how does it work? To make sure people know, because in some cases, if you say no, it makes it hard for them to interact with you. And there's going to be people who sell different versions of this, and we've already seen the marketing. So remember, there's marketing versus legal realities. Let's jump to the next slide. The next slide, hiring a record keeper. And after this, we're going to get to some of the key ongoing plan activities for a good little bit. The hiring of a record keeper, there's a number of steps. There's direct sales, so a record keeper may come to you. As George said, there's a platform provider rule. The scope is still being determined as we speak. And it may be broad or maybe narrower. I think many of us fear it will be narrower, but we're going to have to wait and see. There could be so it could be a direct sale where the record keeper just comes to you, especially in smaller plans, and says, hey, we've got this whole package, you could buy it. If it's general, and it could be that they're not acting as a fiduciary. But if there's specific recommendations on investments in some cases, that can be a fiduciary act, not always. So you need to think, are they acting as a fiduciary? What's their interest? Do they have a conflict? Are they going to make differential compensation in different ways? And in return, you need to be vetting that in your process. So that's going to change. Similarly, sales through intermediaries. What does that mean? Who wrote these slides? It's all techie. All jokes aside, it's us. We know. But the key point on this is, if you have someone like an advisor, a broker, an insurance salesman, you name it, your brother's uncle, sister's cousin, they are an intermediary, and they may have interest. Now, there's some people who go flat dollar or flat percentage of assets. There's some people who get paid on variable level. The rule does not bar any of these models, but it's about conflicts of interest, not barring a method in the workplace, in the business place. So in that case, some of them may say, oh, I'm level, and I'm making a recommendation, so I'm going to get paid on a level basis, and that's in BIC Light, best interest contract exemption, the light version. Or maybe I'm going to get variable comp. So maybe that's why I'm going to get variable compensation, and I'm giving you the full best interest contract exemption. Here's all these disclosures. You as the plan fiduciary need to understand what you're getting and review it. If you've ever had a Department of Labor investigation, the more recent ones will ask you, have you reviewed the fee disclosure notices you get from your clients, from your service providers? And this will become the same thing over time. Will it be tomorrow? No. Will it be in 2 years? Yes. So you want to have a process in place. And again, when you do renewal RFPs, you're going to have the similar type of discussion as well, where you might do an RFI and say, well, we want to take out the bid just to reevaluate your costs and pricing. Fine, not a big deal. But at the same time, remember that there's going to be limits on recommendations, and some record keepers we're hearing will say they will be fiduciaries, some will not, and the scope of what they will do as fiduciaries is yet to be determined. It's important that you dig into this because then it figures into the fiduciary rule for where you go. So, what is this to sort of wrap this up, what is going to change? So when record keeping is track and keep of your accounts, investments are where does the money go? There's the gray line of when it becomes a recommendation on investments. Different record keepers, as I've already said, are going different ways. Platform provider, what is a platform is yet to be determined. There's different people taking different views, and I know that a lot of folks, the folks at Morningstar are focused on this, a lot of folks are focused on this. And we're going to have to see. There's questions and answers due out, hopefully sometime. I think the public statement I heard was in the fall. So we'll hopefully hear it sometime soon. And soon in regulatory speak could be tomorrow, it could be 2 months. But the Department of Labor is working on this and trying to be responsive. And remember that different plan sizes, because if you have over $50 million, some of these sales activities might not require the business interest contract exemption. You would have the independent fiduciary exception that could be applied to you. So let's get into something that I think is a big deal for a lot of people. And we're going to spend a good bit of our time here before we come back and wrap up back at the takeaways. And again, to really close this out as we go forward today. So there's a lot of different things that go on in a day-to-day plan. We tried to give 2 big events. It's kind of like getting married and having a child, picking a record keeping and selecting an advisor. But there's other things that are big deals that go on all the time. Value-added services are sort of thing. It could be everything, and obviously we're doing this webinar with Morningstar, and Morningstar has different solutions. Morningstar did not invite us to do this presentation as a sales pitch for Morningstar today. But at the same time, they have services, they have asset management and educational services, be it Hello Wallet, be it investment advice services, and there's many other services out there. The key takeaway on that is when vetting value-added services, you need to start thinking as we go forward, how is it being brought to me? How are people being paid? What is the money flow on this? Is someone recommending this to me if it is an investment service? It isn't, and it doesn't mean it's wrong. It doesn't mean it's wrong in any formulation. But in some cases, not always, maybe someone will need, and the Department of Labor wants to push people there, the best interest contract exemption, the BIC Lite version, the simplified version, or something like that. So understanding and asking, well, how are you complying here, both the person advocating and selling the service, and does the service itself, once it's implemented, need those types of things? We talk about granularity. That's exactly what we're going for here. Taking another example, participant-level education advice. When you really get down into the weeds, participant education, George was talking about this earlier today during our presentation. There's rules about what is education. The final fiduciary regulation says that certain education services, as long as you meet certain requirements, it's not making a recommendation, provides input and suggestions, but doesn't make any regular recommendation. Might allow you to model, like a modeling tool is another type of educational service that can be done. But there's key requirements about disclosing other investment solutions, all the investments that could fit inside that educational model. There's key requirements, and it only applies to plans, not IRAs necessarily in a lot of these cases. The idea is that as you look at these, you need to say, A, how is the educational service being sold to me? And B, how does it work? Is it truly education or advice? And a lot of people, and we're not ones to talk, we've written opinions for folks on this, about whether something is educational or advice. But dig in and evaluate and say, are you comfortable? And you can look at outside materials, but you are the ones who finally own this, so it's important to look at it. But at the same time, if you have good resources, it shouldn't be that hard. This doesn't need to change your world. Similarly, rollovers into a plan. If people are trying to bring money into a plan, let's dissect this into two different buckets here. If your own employees are not selling investment products and they are helping people decide whether to roll into a plan, we still advise that they be careful and not necessarily push people to move their money into a plan. But the final fiduciary regulation does something that's great. It says employees acting in their capacity are not automatically investment advice fiduciaries, even if they're advising on rollovers. That's a good thing. But don't abuse this. I think if you abuse it, the Department of Labor may find limits to how far it goes, unless you disagree with me, George.
I think that's absolutely true.
But at the same time, you may rely on your vendors or other service providers to reach out. I bet in the future you're going to see more positive outreach. You may have seen the article in the Wall Street Journal a couple months ago talking about the new person trying to gather your retirement assets, your employer. Whether or not you agree with this, and there's different schools of thought, people are trying to retain assets in plans and bring more in for their employees. There's different reasons. But if you do this, your employees have a very clean path. But if you have other providers, the question is, are they getting paid on this? Or they get financial incentive? I think the Department of Labor views financial incentive as a very broad view. And there's the concern that if for some reason the amount they get paid could go up because of the money coming in the plan, that is something to think about. Is it necessarily wrong? No. Could you use BIC or BIC Light? Yes, but that's something to think about. Similarly, distributions and rollovers. There's different schools of thought out there about whether money should stay in plans, should be rolled over out of plans when people leave there, and you can make arguments on both sides. But going forward, unlike in the past in many cases, a recommendation on a rollover is clearly a fiduciary act, where once upon a time it wasn't. There were arguments that it was in some cases and not in others. And so in April 10, 2017, when this rule goes live effectively, you as a plan sponsor will want to understand, well, are people advising on rollovers? Are they not? How are they dealing with the two-step process? Are they fiduciaries? If they are, what's their exemption strategy if they're going to get paid or not going to get paid? That's the process. So what could happen here? You could have reduced activities. You could have people say, we don't want to do things. And you may hear some people say, I can do this or that, or they may have new fees or new charges. I love to refer to it as the great unbundling. The great unbundling that we've seen for years is going to continue. Some people may take fiduciary status, some will outsource to other people. And will there be third parties? And that's the key takeaway. Will there be third parties out there who sort of step in and fill the breach? And the answer is not when, but if, not if, but when. There will be third parties. We work with them in full disclosure. There are people out there trying to find solutions, and that's something that we will see going forward. So with that said, what we thought we would do is turn now to some plan sponsor action steps, which sort of dovetail back to our takeaways. And, I apologize. And I'll hand it to George to talk about those.
Yeah, thanks, David. And I think David did a really great job of touching some of these earlier on, but just to kind of go through them again, short term in 2016 and into 2017, what are things that plan sponsors should be thinking about? Well, first, you need to be asking questions of your service providers about how they plan on complying with the rule. And that means talking to folks who touch and provide potential recommendations to fiduciaries, participants, the plan, anyone who's having those communications, whether it be record keepers, TPAs, advisors, broker-dealers, etc. You need to have that conversation with them to determine whether they have a fiduciary strategy, whether they're going to be a fiduciary, whether they have any conflicts, and if so, what is their conflict mitigation strategy or exemption strategy. Along with that, it's important to review your current agreements. See who's already acknowledged fiduciary status, and think about who that may change with. Talk to your record keeper. Do they expect to change, certain, ways that they do business to deal with this rule? Review existing products and services to understand their operation. Again, all of this goes back to having those tough conversations with your vendors to determine what they're doing and how they're going to move forward. Because, as David said, there are solutions to this. To this rule. There are people who, will be accepting fiduciary status. There will be people who, simply get out of the market and say they're not willing to do certain activities. it's important in the near term to look at the compensation of your current employees. Make sure that those employees aren't paid for providing recommendations to, for instance, the plan committee responsible for the investment of the plan's assets, or they're not paid for providing recommendations to individual participants regarding rollovers. And then, lastly, in the near term, you need to be thinking about monitoring additional DOL guidance. We know that there's going to be additional guidance, sometime this fall, from what we've been told. As David said, we don't know if that's tomorrow or 2 months from now, but some of that guidance will affect your relationships and how things will move forward. So with that, we'll move to the medium term.
Okay, moving on to our our medium-term solution, and this is from the first quarter of 2017 through April 10th when the regulation goes live. What's going to happen is we've talked about this. You want to find out what people are actually doing. They should be giving you documents. Will it be January 1st? Will it be February 15th? Could it be March 25th? Yes. Different businesses are impacted in different ways. Don't assume that someone is playing shifty games on you because it takes them longer. Some people may be ready sooner or not. Complex institutions have complex challenges. So the idea is be ready to move quickly and build some into your planning schedule. A lot of you have compliance calendars. Expect that end of March into early April is going to be a busy time for this topic. It's a good thing to think ahead. Next, to keep in mind, is that's the time to review your revised service agreements. Review the documents, but also match them up to the old ones. Say what they said. We've already talked about this at the beginning, so I'm not going to belabor it. And then review the services. Some will become fiduciary, some will not. We've had a question come in today while we were talking about what do I need to do to become a fiduciary? Do I need to hire someone to make them a fiduciary? Being a fiduciary is a functional test. There is no magic document. You can't write your way around being a fiduciary, but you also cannot, you can just spring and make yourself a fiduciary if you want, but underneath it all is what are you functioning as? So therefore, you don't have to actually sign an agreement to actually just come on board if that makes sense. So review the agreements and say, are these people fiduciary? Have they assumed a fiduciary role at this point? And I think that is a key thing. Similarly, asset allocation models. If you have asset allocation models, some of them could be educational in nature. Some of them might not be. There's very precise requirements in the fiduciary regulation. So if you meet the precise requirements, it might be still considered educational. But if it's an asset allocation model where it's actually like a designated investment under the plan, that's more likely going to be investment advice for someone actually designing and making it as like a core investment option in the plan. But it really depends on the exact circumstances. There still could be cases there where it's not. So it's a balancing act, and I know we got a question on that. Lastly, in the medium term, you should find out what people are going to do on rollovers. That's a big thing to do. Find out what people are going to be doing on rollovers during this time, because that's going to be a big change, and you want to understand where the business marketplace are going. Some people may curtail their activities, some might not, but understand the process and that two-step that we started off on the first page. George, you want to finish us up?
Yeah, sure. So then in the longer term, it's important for you to review and validate the service provider activities against what they've told you and the final regulation. So if they've told you they're going to act as a fiduciary and that they are going to comply with the BIC exemption or some other conflict mitigation strategy, make sure that they're doing that. As we move forward, as David said, there's going to be a lot of, we expect there to be a great deal of enforcement and litigation activity in this space. This is a brand new regulation. Things are going to change. Courts are going to interpret this rule in various ways as we move forward. So it's important to keep an eye on how the department is interpreting this rule so that you're not caught off guard and that your service providers are doing what they need to be doing under the rule.
And I think go ahead, George.
No, I was just going to say, lastly, just reviewing your internal processes to make sure that you have this on your compliance calendar to review your service providers on an ongoing basis. Make sure that both you're doing what you need to do and that they've done what they've agreed to do to the plan. David?
And I think that kind of takes us to the end here. We actually have a few questions. We've actually woven in answers several of them. We have one more I thought I would just throw it to you, George. That we have a reference to reviewing activities and compensation of employees, and we've been asked that if an employee is sole source to plan administration, are they still covered by the exemption that they're not a fiduciary? Yes or no?
Well, if they're sole source to plan administration, and I'm assuming that they're paid from the plan,
and I'll assume for this purpose that they are an employee of the plan sponsor,
right,
not of some outside provider. The DOL tried to crack down on people playing games like that.
Yeah, exactly. But if they are paid to provide investment advice to the individual plan participants, they might not be covered by that exception. But if more broadly they're paid to provide general plan administration, they're paid to interact with plan participants and answer questions as they come in, that's fine. But it's important that those folks aren't paid for the sole purpose, or that their compensation does not change based off of recommendations that they may have on in particular rollover situations.
Great. At this point, it looks like we've been through all the questions, or we've answered them in course of all the different items. We have about 2-3 minutes left. If anybody wants to ask anything else, please feel free to type it in the question box. If not, we'll give it a second, and we can always hand it back to Lynn, our moderator, to close us out. Maybe give it a minute, and if not, we will. Any closing thoughts from you, George, while we talk?
No, I thought that was one.
Okay. Yeah, well, thank you all very much for joining us, and we are glad you could be with us today. Hopefully this gives you some thought from a plan sponsor perspective. We know that it's so often provider-focused. So with that said, what we will do is hand it back to our moderator, Lynn, unless, Aaron, you have anything to add?
No, thank you so much for the presentation. I hope everybody found it helpful. And I think with that, we'll wrap up.
Lynn, back to you.
Okay, so thanks again for joining us, and that will conclude this webinar.